Hello, and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Geringer, and I am the Extension Legal Specialist in the Department of Ag and Resource Economics. Today, we're not going to have a guest on the podcast. It's going to be me talking about a recent decision out of the Maryland Court of Appeals, looking at, is there a joint employment situation with a Maryland poultry farm manager between the farm owner and the poultry integrator. In this case, it would be Tyson. We'll look at that today and then talk about how that appeal is different or the decision in that appeal is, how it differs from the Court of Special Appeals decision in that case. So we'll go ahead and get started with that. So, you may remember this, and like I said, I will put this in the show notes. I posted about this Court of Special Appeals decisions, which found that a Maryland poultry farm manager was a joint employee of both the poultry farm owner and the poultry integrator, Tyson Farms, Inc. in this case. Tyson appealed that decision to the Court of Appeals for Maryland. And when we look at it, the Maryland Court of Appeals reversed the Court of Special Appeals decision. And we'll talk about why that is. But basically, in the end, what the Court of Appeals decided is that the circuit court properly submitted all of this to the jury, and the jury could make a valid decision that this person, the farm manager in question, was not a joint employee. The evidence of the farm manager being a joint employee was susceptible to differing reasonable inferences. So to go back and give you a little bit of background on this, in case you might have forgotten, we had a poultry farm manager that was hired to work on a poultry farm in Worcester County in 2009 to grow chickens, that was growing chickens for Tyson. The owner at the time hired him to assist the farm owner at the time. The farm owner, passed away in late 2009, and the Tyson representatives trained the farm manager in maintaining the farm and raising the chickens, since the widow of the farm owner was not familiar with any of this. In 2013, she decided to sell the farm to another owner who lived in Northern Virginia. Tyson, in some of the documents, has only agreed to this if to continue the relationship with the farm, if the new farm owner kept a farm manager on the farm. Under the terms of the poultry contract, we've seen these before. We've talked about this before. Tyson retained ownership of the birds, provided feed and medication, determined how long the flocks were on the farm, and provided veterinary and technical advice. The contract included various addendums setting out detailed instructions on how to raise poultry on the farm. Now, the issues become with this. This farm manager began to suffer from an occupational disease disablement, and then he filed a claim against his employer, and the Uninsured Employers Fund became a party to the suit because the owner did not have workers' compensation insurance. The farm manager and then the Uninsured Employers Fund then tried to bring in Tyson's into the claim. After a hearing at the Workers' Compensation Commission, the Workers' Compensation Commission ruled that the poultry farm manager's injuries arose from his employment on the farm, and that both the poultry farm owner and Tyson were his co-employers. Tyson appealed that decision to the circuit court. It went to the circuit court in Worcester County. On appeal, a 2-day jury trial was held with the sole issue of whether the poultry farm manager was co-employed by Tyson's. The jury returned a verdict that Tyson's was not a co-employer of the poultry farm manager. The Uninsured Employers Fund then appealed that decision to the Court of Special Appeals. The Court of Special Appeals reversed the circuit court, finding that the poultry farm manager was Tyson's co-employee. So that's where we get to this. Tyson then again appealed to the Court of Appeals. So the Court of Appeals looks at this, and they look at past decisions. And in those past decisions, the Court of Appeals found that the proper place to determine the relationship between an individual and company to determine if there was co-employment, that's a question for the jury to decide. Typically, when conflicting inferences can be drawn from the evidence on the employee-employer relationship, a jury should consider it. We have that case here. The court next turned to the issue of control exercised by Tyson over the farm manager's conduct. Although the past decisions, the Court of Appeals had highlighted that control was the decisive factor, there are differing reasonable views drawn from the evidence in this case. Looking at the evidence, testimony showed that Tyson had no power to hire, fire, or pay the farm manager. The evidence showed that the farm manager the farm owner asked the farm manager to stay on after purchasing the farm and negotiated pay with the farm manager. Further, the farm owner provided the paycheck to the farm manager, not Tyson. Tyson did nothing to establish the farm manager's work hours, and the contract with Tyson did not require a particular person to live on the farm. They just needed a person to live on the farm. Under the terms of the farm owner's contract with Tyson, the farm owner provided the labor and Tyson provided the chicken feed, medication, and technical assistance. The court agreed with Tyson's argument that the circuit court correctly decided to submit the question of employer-employee relationship as related to Tyson to a jury to determine. The Court of Special Appeals was wrong in reversing the jury verdict. So what we see out of this is, in this case, the Court of Appeals reverses and says the jury verdict should have stood. It should not have been reversed by the Court of Special Appeals. So in a lot of these, I often ask this question to you, why do you need to care about this case? Well, the court's reversal of the lower court decision here takes away some of the uncertainty that I discussed in that prior podcast recording and in the post I'm going to share with this as well. The Court of Special Appeals earlier decision had left many unanswered questions on who might actually be considered joint employees of a poultry company in this situation. Could the farm owner be considered a joint employee in the right circumstances? Because if we think about it and we substitute out the farm manager in this case for a farm owner who's actually on the farm, situation might be enough to be similar. We don't know. This decision seems to put many of those concerns to rest in this question. We sort of know where the line potentially is now. In a similar case, this is the question of employer-employee relationship. The jury should decide it based on the trial at evidence. Now, one thing to point out in this is, and the Court of Appeals stresses it in their opinion, and they asked Tyson about this during oral arguments before the court, that there could be circumstances that vary from farm to farm, and that there could actually be a situation where a poultry farm worker or a poultry farm manager, someone on that farm could be a joint employee of both the poultry company, the integrator in this case, and the poultry farm owner. That again would be a question for the jury to decide based on the evidence presented. The court did not announce a blanket rule with this ruling, but did leave open the door for a situation presenting itself down the road where there could be this joint employment relationship. So if you have any questions on this, please let me know. You can email me at lgoering@umd.edu, or you can tweet me or send me a message on Instagram at the handles down below in the show notes. If you have thoughts on other things we should be covering on the podcast, if you have ideas on people I should be talking to, things you want brought up, please let me know. I always like to hear from people because it gives me a sense of what I should actually, be covering besides the ideas I have that I bring on here. So please let me know. Thank you again for listening and enjoy the rest of your day.